impact of raising the age of criminal responsibility, state of New York. You put in a lot of time into this today, and all the months leading up to this today as well. I know this is not the first time that you've addressed this issue, and I'm very grateful to our governor, Andrew Cuomo, for submitting public policy language. And I would offer, before I read a few remarks, I'd offer some unsolicited advice from the great Arthur Ashe to our senators that are with us today. That is to start where you are. Use what you have and do what you can. With the information that you've learned at this public hearing, with the public policy language that's been submitted to you by our governor, your experiences in your community, your sense of public integrity, and good common sense. As far as the proposal we've been asked to address here today, on page 2 of the testimony, I'll read some brief remarks so that all the members that are here with us today have an opportunity to address you. Counties have supported the public policy goals of raising the age of criminal responsibility from 16 to 18 for nonviolent offenses. But we have consistently raised concerns about the cost, about such a comprehensive proposal, the capacity, the desire of service providers, the identified lack thereof in many areas of our state to deliver necessary services to all those individuals and their families. We've expressed concerns about balancing the rights of victims, public safety, and providing services to those in need. You've heard from the district attorneys, you've heard from the Sheriff's Association, you've even heard from the defenders themselves about the public policy concerns both ways on this issue. This proposal could easily impact a dozen or more county departments and services for each youth involved: probation, social services, mental health, substance abuse, workforce training, family counseling, budget, finance, county attorney, and so forth. In addition, the proposal directly impacts multiple separately elected officers, including the district attorney, the judges of the criminal and family court, the sheriff, and other local elected officials. Another key area of cooperative services is the overlay with school districts and the necessary strategies to minimize absences without leave from the education system. On page 3, the governor's proposed budget again calls for raising the age of criminal responsibility, as I mentioned at the outset, but unfortunately it has been modified from prior years. To our dismay, the governor's latest budget proposal no longer provides 100% reimbursement for all and any new cost incurred by the counties to implement this proposal. The budget provides zero funding to New York City under this proposal, and the estimates for the New York counties will incur $100 million in new costs, with a state assumption that at least $22 million of these costs will not be reimbursable by the state. The new proposal at the top of page 4 also requires counties to meet a variety of conditions before they become eligible for any state reimbursement, including maintaining the state's property tax cap, proving to the state that these new costs create a financial hardship for the county, and 3, providing a plan for the state for implementing the provisions of this new proposal. I'm trying hard not to complain here, and I don't mean to, but the additional challenge in this budget proposal is the expectation that counties will incur $100 million in new state-mandated costs and seek partial reimbursement from the state. You, as a legislature, have made it a priority to establish a tax cap. County property taxes have only been allowed for inflationary growth of about 0.73% in 16, 0.68% in 2017. That's $35 million collectively for all 57 counties outside New York City. Considering that this inflationary increase has to accommodate all items in a county budget, including any new cost shifts that may happen, new tax exemptions, caseload growth in state-mandated programs in health and human services, cost of living increases in state budget to a variety of service providers counties must reimburse, health insurance premiums, workers' compensation, etc., the governor's proposal leaves the homeowners and small businesses vulnerable to property tax increases. On page 6, we believe the budget language needs to be crystal clear, that all incremental costs related to this public policy change be paid in full by the state. Current language is simply not clear, especially in regard to the near certainty that many counties will need to expand their existing staff permanently in order to handle the influx of individuals and their families that will require and deserve an entirely new set of services. Adding to staff will provide reimbursement challenges in that current seasoned staff in many county departments will need to be diverted to address the unique needs of this population, and new staff will need to be hired to backfill for these diversions. A clear process needs to be developed to ensure new costs are not placed on local taxpayers to support a state initiative. I understand the district attorneys have prevented a diversion program. I'm here to report that the counties have successfully used diversion programs in many instances across the state, especially in the vehicle and traffic law, where it is working quite well in about a dozen New York counties across the state. Diversion courts are used in veterans. There's a proposal to expand veterans diversion courts also before you in the budget. Diversionary programs do work, and I'd ask that you give due consideration to the district attorney's proposal. With that said, I'll turn it over to Rocco Pozzi for the New York State Council of Probation Administrators.
Thank you, Steve. It's an honor to be here, and I think as I sat here all day, I think we heard the word probation mentioned many times. And this legislation will have a huge impact on probation departments throughout the state. The good news about that is probation is doing a lot of great work, and we do a lot of great work in the family court, which really goes unnoticed by a lot of people. A lot of people don't even realize the amount of work that we do. We heard today about diversion, about adjusting cases. You know, we heard some numbers thrown out. I can tell you that in the family court, when probation has the opportunity to work on cases, the adjustment rate is pretty high. There's a lot of kids who come into the system. We are able to work with victims. We heard about victims today. We heard about victims potentially being denied some of their rights. That's totally not true about what happens in the family court. As a matter of fact, in the law, if a victim wants to proceed and have the right to go to court, they have the right to go to court. But a lot of times, victims are willing to listen and willing to have probation departments work with these kids, come up with an arrangement. And I think one of the things that we really like in this act is that one of the things that prohibits us from moving forward with a lot of these adjustments is that victims would like to have an order of protection. This new law will allow probation departments to get an order of protection without having to go back into court. So that's going to allow us to adjust I want to, yeah. Somebody spilled water there. I'm not moving because of it. Yeah. And also, the other thing that we like in the legislation is that we can extend the adjustment period. Right now, we have up to 4 months to work with kids, and sometimes that's not enough time. So this law will allow us to have up to 6 months. So we think those 2 additional months really means a lot, because if we can get more time working with these kids, we can get them back home, get them adjusted, and not have them enter into the system. You'll get a copy of our written legislation. Just 2 things I really want to bring up. Is one of the things we don't want to see happen is disorderly conduct and harassment charges, which are now not eligible for juvenile delinquency. In this law, they will become matters that are juvenile delinquency matters, and they will be working their way into the probation department. We have no way of knowing the numbers of cases that will now be coming to probation departments for adjustment that now that are not eligible for this under the current law. So we would recommend, you don't want to expand the net here. You're looking at trying to reduce the net, trying to reduce the stigma of kids coming into the system. This widens the net, and we should continue to treat disorderly conduct and harassments the way we are. They are not eligible for juvenile delinquency. We should be devising diversion plans to deal with them and not have them come to probation departments and come to the courts. A big issue for us, and we heard a little bit this morning, and I wish I could have had the opportunity to talk about the PINS question that was raised. PINS cases are tough cases. And I would tell you that my staff say they rather deal with some juvenile delinquency cases than PINS cases, because they're pretty tough. And the law prohibits, recommended law prohibits the use of non-secure detention on PINS kids. Now, we understand that we don't want to stigmatize kids and we don't want to put them in detention facilities, but we have found that a lot of times with these PINS kids, there is a need to put them in non-secure detention just to stabilize them, to give us an opportunity and us to work with the families to try to work on a plan so that we can get these kids back into the community, back into their environments. So if judges don't have, let's not forget, the judges make these decisions, all right? When we present these matters to the judges and we need to have a kid go into a timeout, a runaway is not going to voluntarily go into they're going to run away again. So that's why we need to put them in a non-secure facility until we can work out a plan to try to prevent them from running away or trying to deal with the PINS-like behavior. Let me wrap this up because I can go on and on and on. This is a huge lift for probation departments. We can do it well, but we need to be resourced. We can't do it within the numbers. I know Steve provided you with the funding, the lack of funding that we've been getting from the state on how the state aid has gone down from a high of about 50%. Now we're down to about 8 cents on a dollar that we get. We can't continue to have that happen if we're going to take on this additional burden. But the one thing I can tell you, gentlemen, is that probation can do the job, and we can do it well. And our adjustment rates are pretty high. And let me tell you this, when we have kids that go to secure detention, which are the real problem kids in Westchester, unlike what people would lead you to believe, that most of these kids that go to secure detention wind up in placement, 85% of the kids that go to Woodfield in Westchester, which is a regional center, go back home with a plan, and they never come back again.
I guess I'll go. I am not Sheila Harrigan. I'm Rick Terwilliger from the New York Public Welfare Association. I'm the Director of Policy there.